I want you to hear what some of the judges, well, not judges, the attorneys are saying. What is a conflict of interest? You're a politician. Somebody comes up to you. Hey, you know what? If you can help me out, then I'll help you out. And sometimes courts, even the smallest impression of doing something for somebody will get you in trouble, much less a bigger thing. So this is what the conflict of interest is and how it applies in some court cases in some jurisdictions and how it doesn't. So we're going to listen to this guy coming up because I really liked him. I'm telling you, he came up and he talked this talk. And we're going to talk in between him talking. But listen in. Closing arguments.
The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment. And you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in Williams' case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship.
So again, did they conceal their relationship? You know, when you have a relationship, you don't really kind of tell anybody, you just do it. But seeing as they worked together, if this was after she hired him, then that's a problem. But if they were in a relationship before, maybe it's not a problem. It all depends what you're trying to prove. Let's see what he's trying to prove.
That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case.
So here go the 6 ones, and then you decide if it's a conflict of interest, because you don't have to prove that all of them are conflict of interest. You don't even have to prove that any of them are conflict of interest. You just have to prove that there's the assumption that you're assuming that it's a conflict of interest. And again, I'm not an attorney, but they are.
Any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing.
So again, they mentioned the church. One of the things with conflict of interest, you heard what we talked about and what she said at the church. Is that a conflict of interest?
On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 USC 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory.
And for that, remember, Fannie and Wade, they have no receipts of anything because she paid them back in cash. So does that kind of sound like something that drug dealers would do? Remember, she's like really big in Atlanta and she's dealt with drug dealing cases. So with her not coming with any receipts to show that she did prove that, you know, she did give money back to Nathan, that's very suspicious.
Based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney. And that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There is no boyfriend exception.
There is no boyfriend exception. Hey, you know what? Can I give Fanny a piece of gum, as they say? Can I buy it? No, because the money that you got, you probably get from Fanny becoming her assistant. So you can't buy her 50-cent piece of gum. Just saying.
The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife.
And was he hiding things from his wife? Because they said he had $2,000 in the bank, and that was it. And then from there, he's making money as Fanny's assistant. But then also hearing Terrence talk about it, he only had $2,000 in the bank that we know of, but had money elsewhere. Because on the stand, Bradley had said that, well, no, not on the stand, in Texas, when he texted Ashley, she asked him about, did he have any money? And he said, yeah, more than the $2,000.
How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand He lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatory.
And he lied about lying. Now, that's pretty much bad about lying. And you're doing that on the stand, and you're an attorney, and you should know that somewhere down the line could potentially get you disbarred.
And the lawyers for the DA's office, they just sat there and let him do it.
He's about to blow off some steam now, because how many of people with Fanni's group knew some of this when they were on stand, that they were lying, but could they say something? No, because Fanni's their boss. Keep pointing.
They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now.
And technically, what trouble are they in? We know Fanni should be in some kind of trouble if she said it right or we understood it right, was that she said she used some of her campaign money to help her out. Now, as a politician or somebody running for office, you cannot dip into your campaign money.
That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church.
Here we go.
I want to focus on why she did that. Mr. Gillen talked about that.
So now we're going to talk about this speech. Listen up to it. You heard, you saw me do the speech. Let me know how you feel.
She did it to deflect attention from her own misconduct and that of Mr. Wade.
So is that saying that maybe she should have said, yes, me and Mr. Wade have a relationship? Now, is it really anybody's business to say that? Or is it because he's connected with her and it might be perceived as conflict of interest? But did you say all that in the church?
She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. And the whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends.
So she pretty much wanted 6 months to investigate the own case that she was a part of. Wow, she probably wanted a breather to get her head together.
There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony.
Yes, and if you're Mr. Bradley, what do you do? Do you feel sorry for Terrence? He got up on that stand that first day And he just seemed uncomfortable. And as his story was being developed more, you really were like, wow, this guy's got a lot of drama. Best friends at one point with Nathan for about 10 years. They had a practice together. He got fired because of sexual, I guess, allegations. And he was the divorce attorney for Nathan, which was interesting. And he said he hadn't talked to him in about 2 years, but supposedly a waiter who called Megyn Kelly's show said that they had talked to each other about 2 weeks ago. And when Mr. Bradley was talking to Ashley, the attorney, and they were going to Texas, and she's getting everything about this case. And he's texting her back, giving all the information. Wow. And his last text was, thank you for being a friend or something like that. And then she calls him up on the stage or on the stand, and he says, I don't recall. Anything she asked about in that text, he gives him the papers. And he's like, oh, yeah, well, I guess it does say that. That's what I said. But the day before, you were denying anything and everything. And would you want him as your attorney-client privileges? Because he supposedly gave up everything. And it made you think again, what did this guy do? Because if he gave up everything, did he give up his law practice? Would you want this guy practicing law for you? So the worst person out of this may be Terrence, because he may lose his license. But what if somebody said, hey, you know what? If you give me this information, whatever you're making, I can double it. Yeah, you may not be an attorney, but you'll be happily rich. We don't know. Are there conspiracies? Yes, they are. So listen to this attorney as he continues to talk about Terrence.
Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is no evidence that DA Willis derived any financial benefit from Mr. Wade." That's on page 15.
So if they're saying that, that means there was no money given. But let's say, he's got a job, she's got a job. He treats her. Doesn't matter where the money's coming from. I mean, are they doing the job that they're supposed to do? Is he just out there being a good man saying, okay, I'm going to take you out for lunch? Well, you can't take me out because that's the money that you got that I helped get you the job for and paid you for. So it's like you're double dipping to me. I mean, would she say that? I doubt it.
Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand, and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest.
And this is a case study. It's kind of interesting, but it's so murky through all of this. Some of this can be a conflict of interest, and then some of it may not be. So the timeline technically is, which is interesting, did her and Mr. Wade date before she got that Trump case, or did they date after she got that Trump case?
It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.